Court calls the people of the state of Michigan versus Laura Ann Squire, case number 26-147 FD. We're back here after having been here on the 3rd for a sentence. We sent it back for a revised substance use assessment, which I have received. Before we get to that, council appearances.
Is it all for the people?
Robert Hartzell from Miss Squire joined at the table.
And council, have both of you received this revised substance use assessment?
Yes, Your Honor.
As did we.
Are there any corrections needed to it?
Not on behalf of the defense, no.
No, Your Honor.
All right. Then allocution, Mr. Hartel.
Yes, thank you, Your Honor. As the court is no doubt aware, I am filling in for Mr. Harrison, who is in trial today. Did make sure to discuss the situation with him and the Squire put me on the record. We do realize that this being an operating while intoxicated second will have a minimum of 5 days. We do realize there was a benefit of the plea being reduced from even more serious allegations as well. I would ask the court to consider the minimum amount of time, namely 5 days. I believe she only has 1 day credit, but she does help her husband with her business. I'm told she's basically the brains of the operation, if I understand correctly. And when I used to be an independent contractor, I know my wife would help me and probably would have been lost without me, so I fully understand. There's this construction which has even more moving parts, both literal and figuratively. But she's advised me if the court wanted to, she could turn herself in, let's say Friday at 7 p.m., back out Monday at 7 a.m., something like that. And if the court was kind enough to do at the minimum, we could probably do that in chunks of 2 weekends. What I will also say is she's advised me she's been doing some counseling. She wants to make sure this doesn't happen again. For obvious reasons. She does have good support. Both her husband and her adult daughter are here in the courtroom for support. They have been supportive of her in prior hearings as well. Even when Mr. Harrison was the one allocuting in prior hearings, I would still see them outside, make small talk like we do. In fact, I believe I was the one at arraignment, if I recall correctly. That tends to happen. But what I will say is with them being willing to make sure she has rise to be where she needs to be, that strong support at home, making sure she doesn't perhaps have a moment of, not that you can control if you have a moment of weakness, but that she doesn't have a slip during one of those moments of weakness. It is good just to know someone's there to make sure you're responsible. It makes a difference. But again, I would ask the court to consider the absolute minimum in this scenario and on the weekends. She's realistic. The court will almost certainly want probation. Thank you.
Thank you. Ms. Squire, I forgot to ask, Mr. Hartel brought it up that Mr. Harrison is your actual appointed attorney. Are you all right with Mr. Hartel filling in for Mr. Harrison today?
Yes, Your
All
Honor.
right. Thank you. Ms. Dull, any allocution?
Your Honor, I do believe some jail time is appropriate. I'm not sure exactly what the time credits
1 day.
Already.
She's got 1 day jail.
1 day jail. Your Honor, at least 5 days, if not more. This is a third offense, reduced to a second offense, I believe due to the length of time between the last two. In this one, I am happy to hear that she has started, or she's doing counseling to help address this issue. I would ask for probation to ensure that she continues that to benefit her and obviously the community, because the community is always benefited when somebody who has an issue, which the new substance use assessment states that I believe it's a moderate issue. The community benefits when people who have a substance use disorder seek out treatment and continue treatment and try to maintain a sober life. So I would ask the court to impose the jail time at least necessary by the statute and impose probation with continued substance use treatment.
Thank you. Ms. Squire, you had the right to address the court prior to sentencing. Is there anything you'd like me to know?
Do I stand?
You can stay seated.
Well, first of all, I'd like to apologize to my community. It is a huge disappointment. To apologize to my husband foremost for putting him through this. I don't have any excuses. I'm willing to take responsibility they're willing to do what you hand down to me as far as sentencing, continuing my therapy, and anything else necessary.
So, Ms. Dahl pointed out that this was actually a third. And it's been quite a few years since your last one, about 25 years roughly. But you had those two relatively close in time, about 3 years apart. So what have you been doing over the last 25 years or so to not get another? Let me ask it that way.
Friends, community, therapy, my husband, just living the good life. What everybody wants out of life. We're at the point where we're almost trying to establish a retirement, and I blew that right out of the water. So it's gonna take some time to prove that this was absolutely the wrong decision, what I did.
Have you seen the new assessment?
No, I haven't.
So before we sent it back, because just to refresh your memory, we sent it back because the assessor didn't have the blood results in.
Correct.
And before it was sent back, you had a mild disorder. And then once the assessor reevaluated with the blood alcohol content at a 0.165, it came back that you actually have a moderate substance use disorder or alcohol use disorder. And so there's a few ways you can test. One is to not have any issue at all. Then there's mild, moderate, and severe. So you're not at the top, but you're not at the bottom either. And I am not necessarily surprised by that given the two in your past. So we start with a presumption in these cases that there's no jail and no probation, but that's a rebuttable presumption. And I think well, I shouldn't say that because you pled to a second. So there's an automatic 5 days. But even with that, I think there's still enough here to cause me some concern that I think I need to put you on a period of probation. So I know you had some issues in your past. Ms. Dole, am I correct? I know it wasn't charged, but was she suspended as well?
I did not recall. I don't have the driving record in my file.
Mr. Hartel, do you know?
My client has advised me that she was suspended.
Okay, that's what I thought. So I do think a period of probation is going to be appropriate. I have to impose the 5 days jail. So let's get that over with right now. So it'll be 5 days jail with 1 day credit. I will allow you to serve that on the weekends. So if you were to report at like 5 p.m. on Friday, will that work for you?
I'll make it work.
Okay. So you must report to the jail at 5 p.m. on Friday. Be released at 5 p.m. on Sunday. That will actually leave you with 1 more day to serve because you've already sat 1. And then you'll just follow up the next weekend. Or if you want, you could stay through Monday. That's up to you.
Just knock it out and stay till Monday.
You want to stay through Monday?
Yeah.
All right, then we'll release you on Monday at 5 p.m. I'm going to do 12 months of probation. Normally I would do 24 months, but it has been 20 some years since your last conviction, and you're only testing at a moderate and not severe. So I'm going to do 12 months of probation. During that time, you're not to violate any law, report as ordered, not leave the state without permission of your probation officer, and keep your contact and employment information current. This charge does allow you to be released early from probation. So if you've done everything we need you to do at the 12-month mark, the 6-month mark, you can be released from probation. If something happens where your probation officer doesn't think you should be released, but you think you should, you can petition the court on your own and we'll have a hearing and I'll make that determination as to whether or not you should be released early. While on probation, I want you to attend the alcohol highway safety education class and the victim impact panel. no alcohol, and you'll be subject to testing pursuant to the terms of your probation officer. And I'm also ordering no recreational marijuana. I don't want you trading one substance for another, not that that's an issue or not, but I don't want it to become an issue. I also want you to follow the substance use assessment recommendations, any counseling that your probation officer feels is appropriate, including drug or alcohol counseling, and any additional programming that she feels you would benefit from. There is a $75 Crime Victims' Rights Fund fee, $50 state minimum fee, $250 fine, $150 court cost, $150 attorney fee. I'm only going to charge you for 6 months of probation. That's $180. If something happens that you end up staying longer than that 6 months, you'll have to pay the $30 a month fee for that. Ms. Dahl, is there reimbursements requested?
Yes, Your Honor, to the prosecutor's office and the sheriff's department. This was a blood draw.
All right, so $100 back to the prosecutor's office and $300 back to the sheriff's department. In some cases, the law allows the recoupment for the cost of prosecuting these cases, and operating while intoxicated has happened to be one of those. So $100 is going back to the prosecutor, and then $300 goes back to the sheriff's department to help pay for the blood draw that was done. Ms. Dahl, is there anything I've missed in a judgment of sentence?
No, Your Honor, I believe we also had a show cause for the bond violation for failure to provide a sample. At this point, she's already been sentenced, so I would just dismiss the bond violation.
Okay, all right. Yes.
Going to Monday is 4 days. Because they go in 24-hour increments.
So right now, she's only sentenced to 3 days jail with the 1 day.
All right.
So we're still missing a day.
Yeah. See, I shouldn't be allowed to do math.
If we could just do it on 2 separate weekends, that'd be better.
I do the 2 separate weekends?
Yes, please.
All right, so we'll do 5 p.m. Friday through 5 p.m. on Sunday, 2 weekends. Mr. Hartel, anything else?
No, thank you.
All right, Ms. Squire, because I have sentenced you to a period of incarceration, you do have the right to appeal that decision. If you decided that you wanted to appeal it and could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney. And also, any balance that remains unpaid for more than 56 days will have a 20% penalty added to that, but I'm going to waive that penalty while you're on probation. All right.
Thank you.
Do you have any questions for me about your sentence today?
No, I think you've been more than fair. Thank you.
All right. I'll need you to go out to the front window where you checked in, get a copy of your judgment. Make a payment if you're able to. If not, get set up on a payment plan. And then you'll need to go downstairs to the district court probation and get signed up for probation. And then don't forget about your weekends.
I won't.
Okay. All right. Good luck.
Thank you.
Thank you.
You join from council table.
All right. And we are here for a plea and sentence. I take it that means we've got a resolution. Is that correct?
Yes, Your Honor.
Somebody want to tell me what it is?
Yes,
I didn't know. I didn't want to steal Lisa's thunder.
Your Honor, the people have offered that if she were to plead to operating while physically impaired, we would dismiss operating while intoxicated.
What? I'm sorry.
And the open container.
Mr. Avento?
That is correct, Your Honor. We're ready to go forward with plea.
All right, Ms. Sheldon, have you heard what the attorneys have said the resolution of this case is?
I have to.
And is that how you wish to resolve it?
I would, please.
All right, it's my understanding that you'll be pleading guilty to an added count 3 of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $300. In exchange for that, the people will be dismissing the operating while intoxicated, which is a 93-day misdemeanor, but has other licensing sanctions and costs, along with the open intox in the vehicle. Is that your full understanding of the plea agreement?
Yes.
Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? All right. Back on January 15th of this year, were you on probation or parole?
No, I was not.
Were you on bond?
No, I was not.
Do you remember reading and signing the advice of rights form? In this case, it talked about your rights to an attorney, rights to a trial. Did you understand those rights? Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
Yes.
Other than the plea agreement, has anybody promised you anything?
No.
Has anybody threatened you in any way? And is it your own free choice to plead today? Are counsel aware of any other promises, threats, or inducements not made on the record?
No, Your Honor.
The Miss Shelton, to the allegation that on or about January 15th, 2026 in Clam Lake Township of Wexford County, how do you plead to added count 3 of operating while visibly impaired? In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on January 15th, were you operating a motor vehicle in Clam Lake Township?
I was.
And prior to operating that vehicle, had you consumed some alcohol?
I was at the Eagles in Lake City getting my card. I just got initiated to go get my card and I don't have their meetings till.
Okay.
I had 2 drinks.
Mixed drinks?
Yeah, I haven't drank liquor, but I did that night. And why, I don't know.
All right.
But then I had some pretzel bites and some bar cheese. And it was fine to drive home. Unfortunately, I guess I was not.
Looking back at it, do you believe that those 2 drinks impaired your ability to operate a motor vehicle?
I really do.
Right.
That's why I left actually, is because I just felt it. I needed to get home.
Okay. Do you counsel believe the defendants provided the factual basis to accept the plea and the court rules have been complied with?
You also slid off the road, is that right?
Yeah, I was.
Then that'll help you, yeah. Yes, Your Honor, we would ask the court acceptably and for those.
All right, the court agrees. I find the plea is null and voluntary and accurate. Ms. Shelton, I find you guilty of operating while visibly impaired. Pursuant to the plea agreement, the operating while intoxicated and the open container of alcohol in the vehicle will be dismissed at the time of sentencing. I have received the substance use assessment. Have both of you received that as well?
Yes, Your Honor.
Are there any additions or corrections needed to it?
Yes, Your Honor. Her BAC was on the first page under presenting situation. It states it was 0.012.
Yeah.
Her PBT was actually 0.13. And her blood results came back later at 0.179.
Is Fear Evento any objection to making that correction?
We don't object to that, Your Honor.
Well, this now presents a dilemma for the court because that's way off from what the assessment had indicated. So what I'm going to do is I'm going to request the assessment be redone with those results, and we'll see if that changes the outcome.
Your Honor, while we're discussing the assessment and being redone, there were other errors that me and my client caught that we'd like to correct as well.
Okay.
Thank you. We saw that the legal status, that was incorrect. She did have a retail fraud 3rd from last year for taking some items from a roadside stand.
Does that show in her CCH?
It was not, but it was something that she wanted full candor for the court on.
I was gonna say, because I didn't see it when we reviewed the histories. Okay.
Yeah, in full candor for support, that is there. We're not hiding anything from the court. We're fully honest. And then it also noted in the comments that they're not been used for 30 days. At the time of this assessment, Miss Shelton had just pled to the bond violations, and she wasn't sure exactly when she last used before those bond violations at the time of the assessment, but we are not saying that on the 19th there has been no use for 30 days. That's for sure.
Just a second here. All right, so that correction needs to be made as well. So what we'll do is we'll, Ms. Shelton, I want to make sure the assessor has most accurate information when it comes time to tell me whether or not you have a disorder.
No.
So what I'm going to do is I'm ordering you to go back to have another assessment done. And we need to make sure that they have the accurate blood results and that there was use within the last 30 days. All right. So we will set this then for sentencing. Make some notes. Okay, so you can go out to the front window where you checked in, get your next court date, and just a reminder that your bond conditions continue. Okay? Counselor, I'm sorry, anything else for the record before we break?
No, thank you.
All right, thank you.